Rachit. Good afternoon, everybody, and a warm welcome to the session. Labor codes is a topic that we've been deliberating on for quite a while now. Given the significant change that's involved, organizations have been focusing on understanding and aligning themselves with the upcoming regulation. In this session, we're going to be focusing on how the labor codes impact organizations, and specifically from a policy and a process change perspective, what do organizations need to do? If you can move to the next slide. In today's discussion, as part of our agenda, we're going to start with a quick overview of the codes, what is driving this change, what we expect to see from the new codes, and what is the status of the codes today, be it the central rules and the state rules. We'll also focus on the impact that the labor codes have on organization from a financial impact perspective, from a compliance perspective, what do companies need to do, and do a deep dive on the policies and the processes that they would need to relook at and develop as we go along. We'll call out some areas of challenges and aspects, and we hope that the authorities will provide more clarity on some of these, and then sum up with a quick discussion on what should be the approach, what should be the approach of how organizations should be better prepared to be in a state of readiness for the labor codes. So let's start with a broad overview of the labor codes, what the intent was and what is the current status. As we are all aware, the four labor codes, the code on wages, the code on social security, the occupational health, safety, health and working conditions, the industrial relations code, all of them have gone through the parliamentary approval process, and we have received the presidential assent. The only part now that is pending is the notification from the central government of the date of effectiveness. The four codes subsume 29 of the existing central labor regulations, and once the codes become effective, these individual legislations will be repealed. With the objective of simplifying and consolidating the regulations, the terms that are used in the codes have been made uniform across the four labor codes, be it the definition of wages, employee, employer, worker, contractor, contract labor, and so on and so forth. The codes also provide for maintenance of records, registers in a digital manner. The filing can be made online. Clearly adopting to technology, the changing needs and environment, and enhancing transparency. The codes provide for adopting a concept of inspector and facilitator, where the inspector assumes the role of a guide while organizations transition over to the new codes. The codes have also introduced a concept of a limitation period, which is 5 years. And this approach will definitely augur well for ease of doing business in India. It calls out specific non-compliances and related penalties, which are extremely stringent as compared to now, clearly providing a direction that there's going to be a significant focus on effective enforcement. In terms of the current status, while the draft central rules have been made available, most states have also come out with their draft rules. Radhika, if we may go to the next slide. Going on to the next slide, this provides a visual on the 29 labor regulations that are going to be subsumed under the four labor codes. The code on wages, which subsumes regulations related to wages, which are the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act. The Code on Social Security subsumes 9 legislations and covers aspects related to employees' compensation, provident fund, ESI, maternity, gratuity, and so on. The Industrial Relations Code subsumes 3 legislations, which are the Industrial Disputes Act, the Standing Orders Act, the Trade Unions Act, The OSH code, as we call it in short, subsumes 13 legislations, which are mainly the Factories Act, the Contract Labor Act, and various other regulations which are sector specific. Radhika, the next slide, please. This slide provides the current status of where we are with respect to the state rules. As you can see, most of the states have come out with their draft rules. More recently, between July and August 22, Tamil Nadu and Andhra Pradesh have come out with their draft rules as well. Amongst the larger states, West Bengal is yet to issue their draft rules. But clearly, looking at this map, the government has put in significant efforts to get most of the states onboarded. Before we go on to the key impact areas, let me turn over to Saraswathi and request her for her thoughts on when the codes are likely to get notified and where they stand now. Saraswathi?
Sure, Tapati. This is a kind of dicey question, I would say. I know the past 2.5 years, we've all been watching the labor codes come into the current shape. Yes, as you said, Tapti, the presidential assent is done. I think the government is ready with the rules. There are certain open areas where where there's been an ask both from the industry as well as from the trade unions for the government to make some changes. But the sense we get based on conversations we are having with the various authorities seems to be that they may not wait for the perfect code to be in place. They may go ahead with whatever is possible to be amended by incorporating clarifications in the rules. Clearly, the changes to the basic code may not come in because it's already got the presidential assent. The ask from the industry has been to give at least a transition time of 3 months during the various conversations. So my sense, Tapti, is that the codes could come into play April 2023. January now seems to be very close because we are already end of November and we still haven't seen any announcement. So April 23 seems to be the most likely time, Tapti. And I would say that the government will also be under pressure to sort of implement them because there's been a lot of effort that has gone in to get the states onboarded. So I'm sure they wouldn't want all these effort to go waste.
Thanks, Saraswathi, and keeping our fingers crossed on that. So let's move over to understand more on the impact of the codes. We know that the labor laws are being revamped after a long gap, and we've seen many of the existing regulations that are getting subsumed. What does this mean for organizations, Saraswathi? Do they continue to do what they are doing, or are there significant changes that they need to now get geared up for?
Sure, Tapti. I think it's important for organizations to understand that while there are these 29 regulations which have got subsumed, the impact on organizations is going to be significant and different from what they're doing today, basically because of the change in approach. So as you called out, Tapti, the definitions are now uniform, which means that, say, terms like wages, who's employer, all of that are going to be different from what is there today because the unified definition is applicable across all the codes. So if we just start with the new definition of wages, and I would categorize this change as the key change which triggers financial implications to organizations, because it does have impact on the gratuity payout of organizations, how PF is going to be calculated, and so on. So if I can take some time to talk about the new definition of wages, unlike the earlier definition, say under the gratuity, which was very clear, which said basic plus dearness allowance, or under PF, where certain allowances were specifically called out and excluded, and everything else had to be included, and so on. Today, the definition of wages is a little complicated one. It starts with all remuneration. There are certain specific exclusions. These exclusions could be components like HRA, statutory bonus, PF contributions, and so on. But the total of these exclusions cannot be more than 50% of the remuneration. And then there is a provision which says that benefits in kind should be added to as well. While there are no rules that are available till now for benefits in kind, the question that comes up is how do we value car lease? Is there a need to include stock options and so on? The intent of the government does not seem to be going that way. However, the limited point I just wanted to call out is the definition of wages is indeed a complicated one. And effectively, at least 50% of the total remuneration would fall under wages. So, say an organization has got only about 25% of the total fixed remuneration as wages, and if they are moving towards 50, there is going to be a past gratuity liability on that additional 25 to in the example that I called out. Again, and this would be an ongoing cost as well, because gratuity cost every year has to be accrued. So it's going to have two dimensions. From a PF perspective, again, while the statutory wage ceiling is there and we expect it to continue because of the continuity of the scheme, again, organizations have to evaluate, are they at least contributing on the statutory wage ceiling? If not, there could be additional contributions required there, again, impacting the take-home pay of employees. It's also important to see that the new definition of wages would be the qualifying wages to determine whether the organization is meeting the minimum wages criteria. For the purpose of overtime, again, this would come into play. Coverage under ESI and statutory bonus. And all of this could have cost impact in terms of what the organizations would need to meet. From a maternity pay and creche facilities, while broadly the provisions continue, there could be certain aspects relating to creche that organizations need to look at in terms of accessibility to women, and that again could have cost impact. The other key thing that is changing in the code, especially in the code on social security, is the extension of social security benefits to the unorganized workers. And depending on whether the organization could be categorized as an aggregator. So an aggregator is somebody who's defined as, there are certain specific categories who are called out. So anybody who is providing a marketplace could be considered as an aggregator. So we could have the right providers, you could have the market, e-market, all of these categories could come under the definition of aggregator. And any aggregator who uses the services of a gig and platform worker. So essentially a gig and platform worker would be somebody with whom the organization does not have an employer-employee relationship, but would have no availing services through them. And there could be a remittance which is required to the Social Security Fund, which could be to the range of 1 to 2% of the amounts paid to these gig and platform workers. There is a ceiling, of course, not more than 5% of the total turnover of the organization would be required. Again, if the organization is not an aggregator, we should wait and watch for the scheme that the government would come in shortly in terms of unorganized workers that organizations are deploying. Again, from a leave encashment perspective, it is similar to gratuity, I would say, in terms of the cost that is the leave that is being carried forward. And there again, leave encashment is required to be paid based on the new wage definition. So again, there could be an impact depending on what the organization is paying for today. The other thing to note is from a retrenchment compensation, and there is a need for organizations to contribute to reskilling fund, which is about 15 days of the last average pay of an employee. This is an additional amount to be paid over and above the retrenchment compensation, which is again paid at 15 days wages for every completed year of service or part thereof. So there are certain areas where financial implications there. It's important for organizations to do a deep dive. Moving on to the other aspects which we would normally look at, broadly compliance. I think it's important for organizations to, especially those who are deploying significant number of contract labor, to identify which are the areas where they are deploying contract labor. Are these in core activities? And core activities has been defined as anything which is core to the business, where the core activity of the business. And there are some examples given of non-core activities. This could be security services, facilities management, catering and canteen facilities, and so on. So those are areas where contract labor could be deployed. There are some exceptions provided for deployment of contract labor in core activities. So again, an area where organizations should do a deep dive. Broadly, it's important, as I called out earlier, that the labor codes are being extended to beyond the regular employees of an organization. So it's important to identify who these could be. Gig workers, platform workers, we did talk about that. Even within the regular employees, look at women workforce. There's a different set of compliances to be maintained. International workers, Provident Fund could be different. If there are expats, they could have additional gratuity coming to them because of the concept of fixed term employees. Even for fixed term employees in the past, retirement benefits were not there. So it's important for organizations to look at the broader workforce and see what compliances come in. The process or the approach organizations take up in terms of setting up safety committees, grievance redressal committees, all of these, there are specific guidelines provided. While organizations may have many of these are existing, it's important to make sure they are aligned to what is specifically provided for in the codes. So again, a double check on the compliance is there. From organizations who have interstate migrant workers would need to look at having an additional cost on account of journey allowances being provided. It's also important to make sure that there are healthy working conditions which are provided to them. Tapati did talk about the concept of inspector come facilitator. So we may need to see culturally how this changes on the ground and how organizations can manage the queries through them. The forms and filings there is a change. While they are digitally, no, it's permissible to maintain it digitally. It's important for organizations to realign into that. From a policies and process perspective, and I know we will go a little more deeper into this, but I would say wage definition is one of the key areas which are triggering challenges on account of compensation and benefits. There is a need to relook at that. There are wage settlement timelines which are provided. So clearly the payment of wages chapter act, which is there today, was applicable only to organizations who had more than employees earning less than 24,000, earning though more than 24,000, these provisions were not applicable. But this limit has gone away, which means that there are certain compliances which are triggered, which definitely have an impact on the payroll processes. Equal remuneration, non-discrimination basis gender, and clearly the term uses gender. Earlier, the terms male and female were used. So clearly there is a need for organizations to relook at these provisions and make sure that there is equity and diversity in there, which is reflected in the policies. Overtime, women, especially getting women to do overtime beyond 7 p.m. to 6 a.m. in the morning, there are additional provisions which would need to be, which would definitely impact their policies and processes. I did talk about leave encashment and maternity benefits. Retrenchment policy may need to be revisited given the additional payments that are required. Standing orders, now it's being expanded to all industrial establishments, and definition of industry is pretty wide. We can look at it a little more in detail, but these are broadly the areas where there is a need to look at policies and processes. So I thought I'll share some very key points, Tapti, and maybe we may need to, we can look at some of those in a little more detail.
Thanks, Saraswathi. Clearly, a lot that organizations will need to do to be in a state of readiness, be it from a financial impact perspective or from a relook at the policies and processes that they have today to realign themselves with the new codes. As you can see in this slide, here are some specific policy and processes that we would, aspects related to the codes that we're going to be covering today. Let me turn it over to Radhika to share some thoughts on the policy aspects from a compensation and benefits perspective. Radhika, we've heard Saraswathi talk about the new wage definition, the financial impact that the new wage definition will have on an organization. So what are the specific policy aspects that one would need to be mindful of? Could you take us through that?
Sure, Tapati, and thanks for bringing this up. Now that Saraswathi has already talked about the financial impact on account of the new wage definition, I will first start with the policy side and then move over to the process changes also that may be required. First up, let us look at the impact on account of gratuity. Now, we know that gratuity, because of the new wage definition, we can have an impact both on the accrual as well as entitlement and payouts. Now, from a policy perspective, companies may have to first see what is their current policy and whether they intend to change it. When I say what is their current policy, what is it that gratuity is being computed on now? Is it last drawn basic? How is it being called out in the policy? Is gratuity part of CTC or is it kept outside? And then whether gratuity is capped, which means is it kept at the restricted to the statutory limit, which is 20 lakhs currently? And then is gratuity funded through the trust, or is there an insurance that the company is having for the purposes of meeting the gratuity liability? Now, these are some of the primary aspects that companies will first have to see. And then whether they're going to change it, whether they're going to carry it forward in the same way will actually determine what policy changes will need to be made. For instance, if they decide that gratuity will continue to be a part of CTC, there is going to be a hit on take-home pay. And then again, if you are going to say gratuity today is uncapped, going forward, I will want to cap it, then you will have to call it out in your policy that gratuity will be capped at the statutory ceiling limit of 20 lakhs. This will also have a bearing on the employment letters which are being issued, because traditionally we see there is a line on gratuity in the appointment letters where they say it will be as per the statutory terms. So going forward, if it is going to be capped or if it's going to be uncapped, these are some of the clauses which may have to be called out in the policy. And again, when it is going to be uncapped, how are you going to manage it? Whether the employer is going to bear it on a one-time basis, whether they're going to roll it forward to the employees if it is part of CTC. Not necessarily in the policy, but they will have to communicate all of these changes to the employees through appropriate communication and ensure that everybody is aligned to the changes also. Again, when gratuity is funded through the trust route, the trust deed may have to be reviewed to see whether changes need to be made to the clauses, basically on how gratuity is going to be determined, then whether there is a cap. Again, on the same points, the trust deeds will also have to be reviewed and changed. And the appointment letters will have to capture all these changes. The second part will be on PF. Again, PF, we can bucket it into 3 categories based on the salary limits for those drawing above 15K. While I think there would not be an impact from a financial perspective, however, we will have to see what is being called out in the appointment letters, like how is it being worded? Whether they are saying, is it going to be on basic salary? Is it going to be as per the statute? Because that could have a bearing on what it will be going forward. Also, if PF is capped today for these people, that is, if the contributions are determined only on the ceiling limit of 15,000, going forward, how would you want to do it? Whether you want to make a change, what is it called out here? All these things have to be appropriately documented and communicated. Some of this will come in your employment letters itself. Some of it will have to be captured in the PF, the comp and ben policies. For employees drawing less than 15,000, there's definitely going to be an impact, as Saraswathi called out. So there you will have to indicate that Provident Fund is going to be determined based on the new wage definition. And then for the international workers, companies may have to review the policy that they have today on the international worker front. Again, what is PF contributed on today? Is it going to be, is it on full salary? Do they have a specific compensation structure which is aligned to the domestic population? If yes, do they have components which would be specifically excluded for PF purposes? These are some of the aspects which companies will have to revisit and then see how they can realign their policies. The other area where I think a policy change or even a new policy would help is on overtime. And this is because there is a difference between the eligibility as per the code on wages and the OSH code itself. The wordings used under the code on wages is that overtime is applicable for all employees for whom a minimum wage is going to be prescribed. However, the OSH code caps it only to workers. So it will be good to have a policy which calls out specific details like who is going to be eligible for overtime, what is the type of workforce that the company has, and who all will get covered. What is going to be the overtime hours? Like the statute says 8 hours per day, 48 hours per week. It should not be more than 125 hours per quarter. So it is better to put all these documented how will you calculate the excess hours? Now, that is going to be a significant area for companies to look at. Is it going to be based on just the timesheets that the employee clocks, or is there a managerial approval which is going to be required? All the more so because today we have a hybrid work, people working remotely. See, if you're in office, it is a different ballgame. It's easier to track how long people are working. But when somebody is working remote, if there is a hybrid mechanism which is in place, how is the hours going to be determined? What is going to be deemed as overtime? Because overtime has to be paid at twice the normal rate of wages. And again, wages for that will be based on the new definition. So we are talking of a significant impact here, and therefore it will be important to have a specific policy and detail out everything upfront so that tomorrow there are no two interpretations which are happening. And of course, we are waiting for a clarification from the government on what the intent for overtime is, whether it's going to be across the board for all employees for whom minimum wages are prescribed, or is it going to be as provided under the OSH code, that is to the worker class alone. Again, staying on overtime, when you have specific allowances, today we have seen people having some specific components in their structure like on-call allowance or holiday allowance. And what happens is only when they stick a claim and then the manager approves it, does it get into your payroll system at all and becomes eligible for payment. So how would you take this for overtime purposes? Do you think it will be wages right when the person claims it or even before they claim, or does it happen after the manager approves? If yes, what is the time period that you're going to have for this? Simply because you do have time periods by when wages need to be paid also. So these will also have an impact, and therefore it is important that your policy captures all of these changes and the procedures properly to align with the new labor code provisions. The other aspect will be on the realignment itself, because today I'm sure a lot of companies would have done the financial impact based on the new wage definition. So they know where they stand today based on their existing structure. They would have done the analysis to see whether they would want to introduce more new components, we would want to change the limits which they have in place for different components, or whether they will want to do a realignment between fixed and flexible, move more from a flexible to a fixed. And the reason why I'm saying move more towards fixed is to minimize the uncertainties in wage definition. And also, if you have a flexible basket where each employee chooses a different category, then even within a particular grade of workers, you may have different wages, and it's going to only increase the complexities. So when you have a realignment of compensation structure itself, then these will have to be appropriately documented in the policy as well as in the employment contracts which are shared to the employees. Those were on the policy side. We also have related process changes which may have to be done. First and foremost, of course, is to determine wages in an ongoing manner. And why? Because this wage is going to be the basis on which all your retirement benefits, all your entitlements for bonus or ESI, everything actually is based on the new wage definition, and therefore it is important that it is calculated in an ongoing manner. And the second reason why it has to be done regularly is because there are certain components in the definition itself. For instance, if you take overtime or you take sums paid to defray special expenses, now these may not come every month. These could come staggered. So wages in 1 month may technically not be wages in the second month or the third month for certain categories of employees. Given that, it is important that you calculate wages in an ongoing manner and ensure that the compliances are correctly done. Of course, there is a representation made whether wages can be calculated at the start of the year, whether it needs to be done monthly or annual, whether a true-up is permissible. But till we wait for clarifications from the government on that front, as I read it, it has to be determined on an ongoing manner, and therefore you will have to have robust process in place which can help this. Second, what they already called out was the coverage under the ESI and statutory bonus provisions because of the new wage definition. Therefore, your process will also have to be realigned to ensure that you capture the new wage definition correctly. You get new employees who qualify on board so that you don't miss out on the compliances, because any default in compliances comes with stringent penal consequences. Third bucket will be on the minimum wage compliance. Minimum wages need to be met. We do have floor wages. We are going to get state declaring the minimum wages, which could either be on par or at a higher level than the minimum wages. It cannot be lower than that. But then again, the way companies have been determining their wages will play a significant part in whether the process is going to undergo a change or not. How it matches with the new wage definition, that is where a process change will trigger. If they have been doing it a little differently, if they have been taking all components going forward, the wage definition is different. Therefore, some components may need to be knocked off. The minimum wages could come down. So they will have to see how they can realign. And all these process and policy changes, of course, need to be documented correctly, put in place, and communicated to the employees. Because in certain aspects, there is a clear mandate under law itself that the communication has to be done in writing and electronically to the employees. The appointment letter is a clear indication where even the details are individually spelled out, and they've said, if you don't have this in your current letters, please reissue. The codes also provide formats for pay slips, the employee registers, which have specific aspects which are need to be included. Therefore, if today your current pay slips or your registers do not capture all of these requirements, then the processes will have to be accordingly modified so that the compliances are met on time and completely. So those are on the policy and process side when it comes to compensation and benefits. That is one part. When we say compensation related policy and process, I think a related aspect would be the payroll related side. So Saraswathi, if I could hand it over to you to take us through the payroll related processes that you see.
Sure, Radhika. And as I see the wage settlement timelines, this is, I did touch upon it. This is triggering from the code on wages from the chapter relating to payment of wages. So as I mentioned earlier, payment of wages was applicable only to a limited population under the current act. But when it comes to the labor code, if you look at the code on wages, the applicability is to the entire employee population. There is no restriction or there are no wage limits set in from a payment of wages perspective. So clearly under the payment of wages chapter, there are clear provisions which says what is the period within which organizations need to settle wages. These are reasonable timelines. So for instance, if we look at monthly wage, which is the most common one we would see in an organized sector, the timeline is for settlement within 7th of the subsequent month. Fair enough. It's very easy. It's very acceptable date, I would presume. But it also says that the wage period cannot exceed 1 month. That is the largest timeline within which wages are required to be settled. So what happens when an organization onboards employees in a particular month, and these onboarding happens after the payroll cutoff date? So clearly, when that happens, such employees typically their wages would get processed in the subsequent wage period, which means that the wage period is going to exceed 1 month. So what do organizations do? Do they need to crunch the timeline between the payroll cutoff and the payroll actual settlement date? Or will they need to look at a situation where possibly there is an off payroll cycle that is run to manage this timeline? So these are decisions organizations would need to look at and then reflect the same in the payroll process. Similarly, for exit cases, and this exit cases here would include everything. It would include resignation, termination, retirement, all of that. And for that, the timeline given is only 2 working days. So and this is wage settlement. Thankfully, it does not include gratuity, but even for settlement of wage, organizations do have standard procedure in terms of getting a no due confirmation, how our assets are rendered, especially when there is this work from home or remote work. How do we make sure that the laptops or any other asset that the employee is holding, how do they come back to the organization within such a short working period? Is there again a need for organizations to standardize on the exit days so that managing these become easier? So these are decisions organizations would need to look at. Again, the other thing which is again interestingly included in this chapter is the capping of deductions. So recoveries and deductions is to be capped at 50% of wages. And the section 18 of the code on wages provides a listing of what are the specific deductions that can be made. So organizations would need to make sure that the deductions that they are making from their employees are specifically called out in these provisions. That is one. And two, the quantum of such deductions do not exceed 50% of wages. So, and if it does exceed, then there is a need to carry forward that and recover in the subsequent months, again, making sure that the 50% is not exceeded. So these are system changes that organizations would need to look at. And of course, there is a lot of deliberation and decision making that is required to be done to ensure that they are able to meet these requirements before the payroll process changes happen. And if we can go to the next slide, Radhika, again, this is quickly from a compliance perspective. There are much more, but we just thought we'll call out some as an example. So for instance, the coverage of ESI employees from an ESI and a statutory bonus perspective are going to change. So we factor in from an ESI contribution perspective, who are the new enrollments or who are the cases who are no longer going to be enrolled, capture that. Again, there are timelines provided in terms of settlement of wages in case of death or on account of absence of, and if there is no information with regard to the employee's whereabouts, then there is the amount is to be paid to the nominee within specified timelines. Otherwise, it's supposed to be paid over to the appropriate authority. There are guidelines around this. Gratuity, again, 30 days, it's a settlement timeline is provided. We said on payment of wages, again, on exit cases, again, there is a process which is provided for that, and that needs to be complied. Overtime calculations, we will talk about it maybe a little more in detail, but broadly, overtime applicability at double the wages is something that organizations definitely need to look at. There is an inconsistency in terms of applicability of overtime between the Code on Wages and the Occupational Safety, Health and Working Conditions Code. But having said that, under the Occupational Safety, Health and Working Conditions Code, it's applicable to workers and it's mandatory to pay double the wages. Again, there are limitations on overtime hours that need to be that employees can be asked to work on. And again, these are things which organizations would need to put in processes for. So that is on these two aspects, Radhika. Let me just pass on to you to talk about leave and maternity benefits.
Sure. Thanks, Saraswathi. On the leave with wages and leave encashment side, this has been a hot topic ever since the codes have come into place, the new provisions. There are changes both in the eligibility as well as in the quantum which a worker will get entitled. So under the Factories Act, a worker was entitled for leave with wages if they have worked for 240 days in a calendar year. Now under the OSH code, this is 180 days. There is a change in the timeline. A worker, if he has worked for 180 days in a calendar year, will become eligible for leave with wages. The other aspect is there is no concept of leave going elapsed, because as per the provisions, 30 days of leave can be carried forward. And if a person has leave which is in excess of 30 days, then that will have to be encashed. In other words, the employer will have to pay it out in that year. That is not going to get lapsed, or the worker is not going to lose out on account of this excess. The other aspect also is a worker being given the right to demand encashment of leave at the end of a calendar year, which even if it is 30 days, for instance, I decide that I do not want to carry forward 30 days, I want to carry forward only 25 days, maybe I could ask for encashment of those 5 days. So we do see some of these changes which are coming in, and this could have some cash flow impact, which employers will have to be mindful of and factor. Because at the start, when you have workers who have leave, when they have accumulated more leave, because if suppose somebody has 45 days or somebody has 50 days and there was no policy to cap it, then going forward, if it's going to be capped at 30 days, the 20 days will have to be paid off. And this calculation will have to be done based on the new wage definition and not based on the earlier limits. So we are going to see an impact initially and then on an ongoing basis, similar to gratuity. One point is on the entitlement, it's similar. You have 1 day of leave for every 20 days of work. So you get 18 days of leave per calendar year. However, challenge comes when you have overlapping provisions between the OSH code and the Shops and Establishments Act, which also has provisions relating to leave with wages. Now, while the OSH code caps carry forward to 30 days, we have seen that the State Shops and Establishments Act have a much higher number. For instance, Tamil Nadu and Karnataka have 45 days which can be carried forward. Now, if that is the case, which is the policy which is going to be adopted? Which ones should a company adopt? Do they take 30 days? Do they take 45 days? Again, when there is, you have multiple locations where they have presence for a company, and you have differences between the rules under the State Shops and Establishments Act across these different locations. What is it that the employer is going to do? Are they going to have a uniform policy? Are they going to have different sets of policies? There will also be another challenge which employers will have to factor in. Like, see, under the OSH code, it is applicable only to workers. But do they want to have dual policies, like one for the workers and one for the wider employee population? Or do they want to have it a uniform policy? It also depends on how they are doing it today. If they have a uniform policy today, do they want to change it going forward? Or do they want to give a beneficial provision across the board to all categories of workforce? So these are some of the aspects which companies will have to look into and then take a decision. Maybe they will want to take a beneficial provision because labor being a welfare legislation, they may want to go with whichever is more beneficial, but there they will have to factor the cost impact and then see, do a balancing act. The other point is on maternity benefits. Predominantly, the provisions which are today existing under the Maternity Benefits Act are being carried forward into the Code on Social Security, the chapter relating to maternity benefits. We do have a maximum period of 26 weeks for maternity benefit, out of which at the most 8 weeks could be before delivery. And then we do have restrictions on employing women immediately before or following delivery or termination or miscarriage. They cannot be employed in dangerous or hazardous work where it involves long hours of standing, which can cause physical hardship. There is restriction on that. And it is also to be noted that this is mutually exclusive to the benefit that they will have under Chapter 4, which is relating to the benefits from ESI. So as long as a woman employee is not entitled to a benefit under ESI provisions, they can continue to avail the benefit under maternity benefit chapter. The moment they are eligible or they claim a benefit under ESI, they will not be able to do so under the maternity benefit provisions. Some changes which we can call out is that the maternity benefit will have to be calculated on average daily wage. And again, we are going back to the same topic of the new wage definition. So when you calculate on the daily wage using the new wage definition, you are going to see an impact on the cost side of it. The other point which Saraswathi had called out was relating to the creche facility. It is coming through the rules in more detail, where we are seeing that creche facility will have to be provided by establishments where you have 50 or more women employees employed. Again, there is a difference in wordings between the code itself and the rules. While the rules say 50 women employees, under the code it is 50 employees. So we would have to wait and see whether which one stays. But then they say you will have to provide it within a reasonable distance, which is easily accessible to the women employee. That is, if it is not provided within the establishment itself. And the rules further go on to say that this will also include when a woman is working from home. Now, that is more important because today we do have this scenario where a lot of people are working from home. So establishments will have to make sure that the creche facility is located at a place which is easily accessible. Of course, there are rules relating to nursing breaks and the commuting time which should be provided. And the creche facility could be either a specific facility which the employer provides, it could be a shared facility, they could use something which the government or a private facility has already put in place, they could share that. However, it has to be ventilated, there has to be adequate lighting, there have to be proper sanitation facilities. And lastly, all the benefits under the maternity benefit chapter will have to be communicated to the woman employee in writing and electronically right at the start when the person is appointed. So given the fact that it has to be in writing, maybe it would be a good practice to have a separate policy which calls out all the benefits and the entitlements for a woman employee so that they are aware of what is available to them and what is not, and what is it that statutorily they are entitled to. So that is something to do on leave encashment and maternity benefits. The next aspect we will take is hiring and onboarding of workforce, what you should do, what are the changes or maybe the new thing that you have to consider. I already mentioned about appointment letters which need to be issued. If you see the OSH code rule specifically provides for certain aspects to be listed out in the letter of appointment. Some of the basics like your name, father's name, Aadhaar, labor identification number, the UAN, whether a person is entitled to PF, ESI benefits, what is the nature of work, what is the skill set level categorization, what is the avenue for growth, what is going to be their wage structure like, what are the allowances which they will be entitled to, what are the benefits that they are going to be provided with. These need to be specifically called out in the letter of appointment. The code further says that if you don't have it in the current letter that you have issued to all your employees, you will have to reissue it. So it's not that it is a something which is coming in for your new joinees. It is also going to be something that you will have to do for the existing workforce as well. Of course, there is an implementation window of 90 days which is being provided. So companies do have time by when they can ensure compliance with this provision. Saraswathi did call out that there cannot be any discrimination by way of gender, and that is a change which is coming up. Earlier, the word used was man or woman. Now we are having the word used as gender. There should be no discrimination by the employer when the work is of the same or a similar nature. You will have to give equal opportunities. An employer is barred from committing any unfair labor practice, which could be in the form of coercing an employee, restricting their rights, not giving them fair proportion, unduly transferring. These are specifically listed out in the schedule to the codes itself, and any of these practices can lead to consequences or penal provisions being brought in. The other aspect is where a vacancy has to be reported. Of course, this is subject to the notification which will come from the government, warranting which class of establishments will need to comply with this. They will have to report vacancies to a career center. There is no obligation to fill vacancy through the career center. It is just that they will need to notify such vacancy to the career center so that everybody is aware that there is a vacancy which is coming up. And again, when we employ women, there are certain conditions. Earlier, they could not be employed beyond 7 p.m. at night or 6 a.m. in the morning. That has been done away with. Of course, their consent will have to be taken before they can be employed at this time. They will have to be provided with adequate transport facilities if they are working at this time. And if they are going to work in an area where it's dangerous or it's hazardous, then adequate safety measures will have to be put in place so that their safety is adequately taken care of, and the workplace has to be ventilated. There has to be proper lighting. There will have to be proper sanitation facilities. There will have to be separate changing rooms. So these are clearly called out under the codes, and therefore, even the policies and the processes which companies have need to be tweaked so that they are aligned to the new provisions under the codes. I am not touching about the retrenchment part of it. We will take it up a little later in this presentation itself. We do have certain specific aspects relating to the broader workforce, and I will hand it over to Saraswathi to take us through that.
Thanks, Radhika. I'm cognizant of time. I think we have talked about the fact that the government now provides for fixed-term employees to receive benefits such as gratuity and so on par with regular employees. Similarly, contract labor, it's important for organizations to look at contractor-related compliances while there is a clarity that the employer definition includes contractor. Clearly, there are specific aspects where the principal employer is still responsible for contract labor, and hence there is a need to review the contractor agreements. And as I called out earlier, it's important for organizations to look at their business model to determine which are the areas and aspects in which a contract labor is being deployed. If these are core activities, it's important for organizations to see whether the exceptions which are provided are met. I'm not going into detail for paucity of time. Gig and platform workers, again, it's important to for organizations to see whether the broader workforce could fit into the category of employees, or are they, say, consultants, gig workers, and so on. The compliances varies depending on the nature of workforce, and hence it's important to look at the documentation. And it's not just documentation, it's actually the facts on the ground. What does the person actually do? How does he or she behave? Is the relationship that of an employer-employee? And then determine on the aspects to be followed. From a social security perspective, gig workers and platform workers, as I mentioned earlier, there is a scheme that the government will come up, and it's important to comply with that. And there would be a need to register them under the eShram Suvidha portal of the government as well. Let me just quickly go to the last technical content slide, as I can say that these are certain areas where it's important for organizations to understand that there are significant changes that are there. For instance, any organization which is a factory with employees more than 500 people needs to constitute a safety committee, and the constitution has to be in accordance with the specified norms. Further, where there is no, if it's an industrial establishment having more than 500 or more workers, then again there are certain provisions which are applicable in terms of constituting the safety committee. If we look at women workers, again, there are provisions which says that written consent of women worker is required for working a night shift, 7 p.m. to 6 a.m. This comes from Section 43 of the Occupational Safety, Health and Working Conditions Code. And it's important for employers, in addition to getting the written consent, to provide transport facility and ensure that provisions relating to the prevention of sexual harassment at workplace is put in place. The governments also have the right to introduce further provisions, and this is also required to be met by organizations. Again, Radhika talked about compliances with respect to maternity benefits and creche facilities. Creche facilities, as I called out earlier, there is a new provision that's coming out in the draft rules, calling out that the approximate distance of the establishment to the creche should be such that it is accessible to the women employee, even if they are working from home. Again, working hours, these provisions are there both under the Code on Wages as well as under the Occupational Safety, Health and Working Conditions Code. We believe the OSH code will prevail. This is based on what authorities have mentioned to us in public forums or in discussions where we've had with them. From an OSH code perspective, the applicability is to workers. So it's important for organizations to determine who is a worker. It is a slightly narrower definition. Managerial and administrative personnel are excluded. If a person is a supervisor, then if they are earning more than 18,000, then the provision is not, the person is not considered a worker, but otherwise it includes employees who are providing manual, unskilled, technical, operational, clerical work also. So it's important to categorize the workforce properly and then determine that which provisions are applicable to workers. Leave encashment, for instance, under the OSH code is applicable to workers. So it's important to look at that categorization. Standing orders, I think the applicability is to industrial establishments with 300 or more employees, and the definition of industry is wide. It includes providing services, organizations providing services as well. So it's important for organizations either to adopt the standard standing orders which are provided by the government, or if they want to file their own, prepare their own, then the same needs to be prepared within 6 months from the date of commencement of the code, and it needs to be filed with a certifying order, certifying officer. Contract labor, I think we've talked enough about it. In the interest of time, let me go forward. Again, it's important for organizations, if you look at the OSH code chapter 3, for instance, it specifically calls out the duties of employer and employee, and paramount among them is to ensure a safe working space. And there are specific provisions relating to this. Organizations need to be mindful of that. Interstate migrant workers, again, for every establishment where 10 or more interstate migrant workers are employed, it is important for them to ensure that suitable work conditions are provided. And in the case of fatal accident or serious bodily injury, to report this to the specified authorities. And also, as I talked about, a journey allowance is required to be paid to them, which is a lump sum fare to and fro from the place of employment to the native place. So there are many aspects which need to be looked at by organizations and make sure that the policies are framed in line with that. In the interest of time, let me pass it on to Tapati, and let us see whether we can take some questions.
Yeah, I think we'd better, we should take a few questions that have come up on the chat, and then let's see if we have time to summarize. Saraswathi, if I can turn to you, as per the existing law related to leave encashment, that's under the Shops and Establishment Act of the respective state, is leave encashment a matter of right of employees, or can this be done only when the option is provided by the employer? If you can, comment on this as per the current and as per the codes.
So there is leave encashment in a way with the carry forward of this is a right of the employee, Tapati. Even under the Occupational Safety, Health and Working Conditions Code, it is mandatory to provide the specified number of leaves and restrict the carry forwards to what is specified under the Occupational Safety, Health and Working Conditions Code. These provisions are applicable to workers. So employees at a broader level, it is not mandatory, but workers, it is mandatory. And it is also important to look to understand that there is no question of lapsing of leave under the OSH code. So they become entitled to encash it so that they do not end up with a lapsing of leave. So employers should look at encouraging employees to take leave is what I would say to meet the conditions of OSH code.
Thanks, Saraswathi. Is the government going to be contributing to Provident Fund for the unorganized sector?
Well, there is a clause which says, if we look at Chapter 9 of the Code on Social Security, there is a chapter on unorganized workers being covered. And there is a mention that the government will also make a contribution. But we'll have to wait for the scheme to see exactly how much that would be. But if it is an aggregator, then there is a clear methodology indicated. But again, the rules will have to come to determine the exact amount. But as I called out, it is 1 to 2% of the amount which is paid to the gig worker, limited to overall 5% of turnover. This is for aggregators.
Thanks, Saraswathi. We are on the top of the hour. Radhika, if you can just flip over to the next 2 slides on the summary and the way forward, and leave it on there for maybe a minute or so, and then we can wrap up. Rachit, over to you.
Yes.
So maybe just to wrap up, I think Rachit is having a challenge. Thank you to Taxmann for giving us this opportunity to present to you on where we are as far as the codes are concerned, with specific focus on the processes and the policies. We hope you found this useful. Happy to take questions through Taxmann as we go along, if you have any questions for us.